Good afternoon and welcome. Sorry, we're a little late starting this afternoon. And just to remind you that we're recording today's presentation. It'll be up on our website. So if any colleagues of yours can't attend, then please do. It'll be on our website in a day or two's time. I'm going to pass over to Paul. Paul's going to be leading the discussion today. So my colleague Paul Balen.
Well, good afternoon, everybody, and thank you very much for joining us. Today, we're looking at court orders in mediation, both from setting it up to the end product of hopefully settlement or resolution. I'm joined today by my Trust Mediation colleague, Brian Dawson, maybe by my colleague Sue Allen as well, if the technology works, and also our special guests, James Weller, Associate Solicitor at Thatcher and Hallam, and Justin Valentine, Head of Clinical Negligence at St John's Chambers in Bristol. So just to paint the picture to start off with, following the Churchill judgment, which I'm sure you're all familiar with, but I will mention again in a minute, the CPR has now been amended to make ADR and its use the overriding objective, and providing what Churchill explained was the case, that the court can, in appropriate circumstances, order dispute resolution, alternative dispute resolution, over the heads of the parties, as well as by consent. And in every case, in any event, case management judges must consider whether to order or encourage dispute resolution. And Part 44 amended to make it absolutely clear, as has been shown to be the case in previous cases, that failure to engage in ADR can be treated as relevant conduct when considering costs issues. And if there was any doubt about it, this whole phalanx of cases here, just a minute example of judgments that have come out in which ADR has made an important part. And Churchill, of course, saying the courts can order dispute resolution, and the parties and the courts will need to weigh up what form of dispute resolution is appropriate in every case. DKH was the case in which the defendants raised every objection under the sun as to holding of mediation, and the court found against them on every argument, ordered mediation, and the case promptly settled. So proof was in the pudding there. Hayes and Holt's the case where the court made it clear it could order a second mediation even after a first one failed, and the same would apply for any other form of ADR. Northampton was a case which illustrated the fact that silence in the face of an offer of mediation can be treated as a rejection and therefore lead to cost penalties. Conway is a case in which the winning defendant lost 25% of its costs for not mediating. Elphick was Master McLeod's last judgment, in which she declined to order a 5-day costs assessment without first the parties holding a mediation in front of a cost specialist mediator, hoping as a result of resolution of various points, it would reduce the court time from 5 days to 1 day. XX is a case where unreasonable refusal to mediate was sounded in a costs order. Barry emphasized that if you're going to object to mediation, then you must have a compelling reason. Otherwise, the court will likely order costs. Dover Farm Developments was an interesting case where mediation was considered to be appropriate. The parties couldn't afford to mediate, so judicial mediation was ordered. Ivy and Lithgow and Fernandez, two Bristol cases, incidentally, and Bristol will feature large in our discussion this afternoon. Ivy and Lithgow, this was a probate case where the judge decided to join a third party who would inevitably become interested, whatever the outcome of the prime case, joined the party and then ordered all three parties to mediate. So just showing how case management can be used to further mediation. And finally, Fernandez, there's a most unusual case where 26 offers of mediation were made and refused, and the party who refused all 26 offers was ordered to pay indemnity costs at the end of the case. And there are many others that you can wade through if you're so interested. So,
Paul, if I can just interrupt you just to say, as I usually remind people at the start and forgot to do today, we've got a question answer tag on your screen. If you've got you'd like to submit any questions throughout the webinar today, please do submit them. We'll try and make sure we answer all of them either as we're discussing, or we'll come back to them at the end if we don't get a chance to pick them up during the time. So you just submit by the Q&A. Thank you. Back to you, Paul. Sorry for the interruption.
Yes, I've just got this quotation from the Chief Justice. This was part of her lecture at the International Dispute Resolution Week held in London in June last year. And it emphasizes the fact that both judges and practitioners need to understand the different forms of dispute resolution and consider which form is appropriate in the circumstances of the case under review. And that exemplifies the reason today that our speakers include both those with judicial as well as mediation experience and those practitioners who become involved in court-ordered mediation. So starting off with that as the background, let's go to Bristol. Bristol's been probably the most proactive court in the country in our experience. This is what appears to be a standard Bristol County Court order made over the heads of the parties simply on receipt of direction questionnaires. And I'm delighted that we have two practitioners with personal experience of how that works. I put up on the screen the order that's made. Accompanying that, there are explanatory notes, and I'll leave them on the screen. As I first of all asked Justin, what's your experience of being counsel in a case in which you've received one of these compulsory orders, effectively?
Well, it's been very interesting. Thank you to Trust Mediation for the invite for James and I to speak. It came as a surprise to both of us that we'd done 3 of these in 2025. There isn't anything on the screen, in fact, Paul, just FYI, at the moment. I do 99% claimant work, and James obviously does all claimant work because that's the nature of his practice and of my practice. We're generally pleased to engage in ADR. The question often is that of timing, and usually from a claimant's perspective, you suggest historically a JSM at a time of, when you think that it's appropriate, which is often after breach evidence has been exchanged, or it's clear what the breach evidence is. One of the notable aspects of the Bristol Stay to Mediate scheme is the time that it happens, because it happens before a CMC has taken place, and therefore before, by definition, in clinical negligence, which is mostly my experience, although of the 3 cases we mediated with yourselves this year, 2 were personal injury and 1 was clinical negligence. But it's before the exchange of breach evidence in clinical negligence claims. And it's before, really, sensibly, the breach evidence can be exchanged. And that's a very interesting phenomenon, because certainly in the first one that we did, which was with your Andrew Hannam in April 2025, that was a delay in diagnosis of a T4-5 metaplastic meningioma. We, as I say, hadn't exchanged any breach evidence. Our first thought was, well, you know, this is too early. How are we sensibly going to do this? We'd received a defence which was denying everything. One of the unsatisfactory elements of it, condescending to particulars of that particular case, is 2 weeks before the mediation, a non-Part 35 compliant 2-page letter was disclosed from the defendant's spinal surgeon dealing ostensibly with breach and causation evidence, and also critiquing the expertise and the specialism of our particular experts, which we dealt with. It settled not on the day, but shortly thereafter. Fortunately, in all of the 3 cases that James and I dealt with, our C&P evidence was complete, our condition and prognosis evidence for personal injury practitioners, which isn't going to be relevant, obviously, if you do personal injury, the fact that you haven't exchanged breach evidence. In the other 2 cases that we dealt with, one of them had been compromised on a 60-40 basis, and one of them, primary liability, had been admitted subject to contributory negligence, but we thought that that was, you know, a non-starter from their perspective. There was no evidence from any of the defendants in any of the 3 cases that we dealt with Trust Mediation on any expert evidence on condition and prognosis. So it was only our condition and prognosis evidence in all 3 cases. My misgivings as to the clinical negligence one was precisely that, well, how are we sensibly going to mediate this without breach evidence? But to be fair, we managed it. And I think it's fair to say, and I explained to you all in our preliminary discussion, that it's made me very much more sympathetic to mediation. I simply don't think that without a mediator, we would have been able to reach settlement, because the defendants would be saying, well, you've simply got no case. Our experts are, you know, completely against this. And our experts say, well, of course, there is a case and it's plain as a pikestaff, and, you know, they really should roll over. So, you know, without a mediator to push both parties to see the litigation risks in both parties' cases, I don't think we would have achieved it. So one of the hallmarks is it's very early. And I think one of the lessons perhaps for claimant practitioners is you need to have your C&P evidence sorted out, because otherwise you can't be in a position properly to value the claim, or as much of your C&P evidence is reasonably going to allow you to put a value on it. And I know, Paul, that you're very much of the view, well, you know, experienced practitioners can compromise a claim even if their C&P evidence isn't complete. And I'm very sympathetic to that. I mean, it's always a curious feature of litigation that schedules work out down to pounds and pence and then add interest up very precisely. But when you step into ADR, you know, depending on the value of the claim, you shift in tens of thousands or even in 50,000 cases without much regard. And of course, nobody's looking at the claimant to know what they're going to be spending the money on afterwards. So precision isn't the hallmark of mediation. So, I mean, that's in broad terms my experience. James, I'm sure you've got some insights to add as well.
James,
James,
just before you comment on that, just to seize on that point you just made about, you know, prematurity, Justin, our experience is currently over 70% of our mediations are pre-CCMC. And talking to defendants, of course, whether they're insurers or the NHS, they've got a vast array of cases behind them that they have access to. So they know what the appropriate reserve is in cases such as this. And increasingly, one anticipates claimants will become rather like you, suddenly realizing, well, you've run a few of these cases in the past, you know what they're worth, you know what the bracket is, and you can responsibly advise your client. What was your impression, James, and much more importantly, probably your client's impression of participation in these 3 ordered mediations?
I think my experience from the start was the first order we got was for the Clin Neg one in April 2025. And usually you spend some time waiting for the court to provide actual directions and then actioning them. And the claim obviously plods on as it does logically along that process. But with the mediation order, the first one came as somewhat as a surprise, but it was a welcome one because, as Justin knows, this first defendant, which was the NHS and a private treatment provider, was liability denied claim from the start. It had been running for about 4 years plus up until that point. They'd made sort of a nuisance offer, and we had quite a high offer outstanding. There was no inclination they were ever going to bridge the gap quantum-wise. There was no inclination they were ever going to provide any of their CMP or breach evidence or any evidence whatsoever to substantiate their own defence, despite asking them to repeatedly. And there's not really much you can do as a claimant solicitor in that scenario whilst you're waiting for the court to actually force the defendants to provide any information or any evidence. So having the mediation order come in, the defendant I had was very, very difficult to deal with. And a lot of that pressure and stress obviously gets passed on to your client. So you get the order, it comes through, and then all of a sudden, the defendant was quite happy to set up the mediation. Quite happy, I was surprised, to come to Bristol, to our chambers, to meet. Quite happy to turn up on the day for a full mediation. They didn't provide, obviously, they provided very minimal evidence on the day. And they did walk away at the end of the mediation when we rejected their last offer. But almost immediately afterwards, we received an offer, which the claimant was happy to accept. And the claimant was under a lot of pressure in those 4 years and a lot of concern because Clin Neg claimants, to start with, don't enjoy suing the NHS. There's a lot of stigma around it and being told constantly, obviously, that they're wrong when they believe they are right, and we do as well. Having the mediator sit with them and talk to them and pursue the claim and talk about its merits and go back and forth to the defendant, the claimant, I think, found very comforting, and it was a big part of obviously why it settled there afterwards.
Well, that's really interesting, and is the kind of views that we're getting from the claimant side as the receipt of these kind of orders develops across the country. And talking of the country, let's move from Bristol to the northwest. Can we, Phil, put up the standard order that judges now have been given as part of their handbook, no doubt, and turn to Brian. Brian, you're a deputy district judge up in the northwest. What's the feel, the experience from the bench side up in your area, and what's in your minds when the parties come before you arguing about dispute resolution?
Thank you, and hello everyone. First thing I have to stress, a couple of things I have to emphasise. Firstly, I'm at the bottom end of the judicial food chain, and that has to be firmly borne in mind. So I don't get a lot of the Clin Neg case management type of conferences to deal with. And obviously, the other thing I'd just stress is that both as a mediator and the judge have to be totally impartial. In the northwest, we have some uptake. I can't say that they have the same proactivity in this part of the world yet that they do in Bristol. But it's here. My own take on it is it's here and it's here to stay. We and Sir Alan will confirm this because we're at the same civil update judicial course recently, where a very senior member of a judiciary came down to give us a talk, and pretty much the first thing he said was that the Lady Chief Justice wanted to emphasise the importance of ADR. Now it's a huge organisation, the judiciary, and like a lot of huge organisations, I suspect things move relatively slowly. So however proactive or not judges are, my view or what I anticipate is this is here to stay, and this is what's coming. So I have a couple of thoughts, which are whilst it may be that hard-pressed local judiciary are pretty overworked and therefore may or may not be proactive. When the issue arises, they will make orders, and I've spoken to the senior full-time judges who deal with Clyneg in Liverpool, and they will make orders where appropriate. And the second point is that my thoughts are that what the senior judiciary, and particularly the Lady Chief Justice, wants, the Lady Chief Justice will probably get, and whether the lower courts are proactive or not, if I could be flippant for a minute, good luck on appeal if you are resisting these sort of orders. And my suggestion is that this is coming down the track, and that the best, my suggestion is it'd be better to embrace it, not least on the issue of costs, which I would have more involvement with. 44.2, as you mentioned earlier, says that the courts will consider various aspects in relation to costs, and one of which is whether a party failed to comply with an order for alternative dispute resolution or unreasonably failed to engage in it. And I think that will become more and more the norm, if I could put it that way. Perhaps if I then hand over to Sue Allen, I think is with us now, also a DDJ. Sue, do you have any additional thoughts or different thoughts?
Yes, thanks.
So you're a deputy district judge, just to explain, in the Midlands. So we're covering the country this afternoon.
Yes, yeah. So yes, I'm a DDJ like Brian, sitting in the Midlands circuit. Now, some people will probably know, in the Midlands circuit, in Birmingham, there is a specialist team of district judges called the SPI team, and specialist personal injury and Clyneg judges. And there are a few deputy district judges also on that list, of which I am one. To be fair, I don't get a huge number of those sittings, but essentially, if you get one of those sittings, you'll get a day of King's Bench matters, very often CCMCs and the like. And my understanding is that there isn't certainly at the moment in the Midlands, there isn't the sort of push that there is in Bristol with the very proactive orders, but that if parties ask for an order, they're very likely to get it in terms of staying for mediation or ADR of some sort. And my thoughts on it are that if a party particularly wants it and has tried either pre-action or prior to the directions questionnaires going in, the other side is being pretty slow about it, then I don't see why you shouldn't really be pushing for it when you make your DQ submission. And judges, like almost anyone, like an easy life. And so I would suggest that if it's something you really want, then you submit the draft order that's now available or something similar. And any correspondence that's open correspondence about it, and push it in front of the judge to make the order. And I think that's the way forward if it's something that you're wanting and the other side is not necessarily pursuing. But as I say, my feeling is that across the Midlands, it isn't as proactive as it is in the Southwest. But I agree entirely with Brian that it's coming. It's probably just a bit of a slow burn as far as I can see.
Thanks, Sue. Brian, is there any experience up in the Northwest of parties accepting the need for dispute resolution, but seeking the judge's help either on some of the technicalities, the mediator to be appointed if it's not a clinical negligence case where there's already a panel, but for example, a personal injury case, or indeed disputing the type of dispute resolution, One party, for example, arguing they want a joint settlement meeting, another party saying they want a mediation or an evaluation and so on. And how, in your view, how attuned are judges to the different forms of dispute resolution available?
I can't give you examples of where parties have fallen out about the mediator or the type of mediation, because the cases where this has been ordered have been cases where one party may object in principle to ADR and the other not, and the judge has ordered it in any event. And as I say, there's not a huge number of those cases as yet. So as to anecdotal evidence as to whether they like JSMs or mediations, I think, Paul, even as a DGG, my experience is probably the same as yours, which is this has been an issue in PI for many years, that parties tend to say, oh well, we don't really need a mediator because we can always settle on a JSM. I think there's been a lot of discussion recently about the advantages and disadvantages. Indeed, it may even be part of this talk now, of each. But I think the bottom line, and that likely to be taken by the judiciary, is, well, if the parties get on very well, then there's nothing wrong with the JSM. But if you can see from the way the case has been handled, that there is an issue between the parties in terms of how they relate to each other, then obviously the likelihood is a mediation would be a better way forward. As to how sophisticated the judiciary is, in general terms, I think not particularly. Although the specialist judges who deal with clinical negligence in the North West, and I'd be interested actually in questions or observations from the people listening as to what their experience is. But I think the judges who deal with clinical negligence are a little bit more sophisticated as to the difference between the various forms of ADR.
Yes, and indeed we welcome contributions from the floor, particularly if we have any defendant representatives listening in and wanting to make a point. Go on to your question and answer button, put your question there, and we'll try and deal with it. Well, not quite completing, but going on with our tour of the country. Phil, can you put up the, here we are. This is a court order that came to us with parties wanting us to organise a mediation. And this court order came from the Northeast. And as you can see, it must have followed a contested hearing because not only does it say the parties must engage in mediation and give a date for it, but the costs of the claimant's application for mediation shall be paid by the defendants and summarily assessed. So that's clearly a proactive district judge in that particular case. The other court order we came across, this is a High Court order, so it came from London. I'm not sure whether it was by consent or imposed. But as you can see, it is, well, hopefully see, Phil, if everyone has it on their screen, it's confusing because it refers to ADR by way of early neutral evaluation. And then it says that has to be defined and agreed by the participants. And then paragraph 2, it's to proceed by way of evaluative mediation, which is really a slightly different form of early neutral evaluation. What actually happened in that case is that it turned out on the day that none of the parties, all of whom were represented by eminent KCs, knew what the order meant, and turned to the mediator and said, can we just do a normal mediation? Normal being facilitative. And that's what happened, and the case settled shortly after the mediation took place. So it is critical, I think, that both the judiciary and practitioners know the different forms of ADR available, and hopefully the standard order that is now in circulation that judges have will aid that. Turning to Justin, I just wondered, Justin, if you've experienced any debates about the nuts and bolts of mediation or ADR, arguments about choice of mediators, particularly outside the clinical negligence field, arguments about venue online or in person, and so
on. Not so much. I mean, normally once in principle it's agreed, usually what I find is the defendants nominate an organisation or two, and then the claimants choose somebody from that organisation, which is a helpful process because both parties have got to have trust in the mediator, of course. I do think, I know you've just said it's important parties understand the different forms and the nuts and bolts. I do think the distinction sometimes between facilitative and evaluative is perhaps overstated, because even mediators who are conducting facilitative mediation are very adept at pressing on the pressure points and the weak points. I had one with Simon Fox, KC, who would simply say, "Can I just invite you to consider, X, Y, Z?" When obviously his point was, well, I think this is a bit of a dud point, and you should move on and consider another one. And I can only assume that that's what he was doing with the other side. And of course, even if it's evaluative, it's not as if the parties are bound by it. I think all mediators, in my experience, and I've done not just with trust mediation, but quite a number now, are skilled at bringing the parties together. And I do think, and this is a point I've made to you before, that certainly there are some cases that I just simply don't think that they would have settled at a JSM rather than a mediation. And the reason for that is simply that the defendants, and I'm going to say it from the claimant's perspective, but it's probably just as true if you swap claimant for defendant, the defendants just simply don't listen. And however articulately and however carefully and whatever sort of evidence you present to support your case, it just seems that there's they just won't shift. But I think they listen more when the mediator takes your good points and presents them to the other side. And I'm sure that's true for the defendants as well, that their experience, they probably think that the claimants don't listen. So that's one of the reasons I'm coming round to mediation rather than a JSM. And I think, the whole point is, from the claimant's perspective, you're normally delighted to engage in mediation. You may have an idea about the risk, but of the litigation. You don't really want to go to trial because obviously everything's up for grabs, and it's phenomenally stressful for the claimant who doesn't want to go to trial. The difficulty we have rather is trying to get the defendants to come to the table, and obviously the element of compulsion there is a useful one. Having said that, I have had both JSMs and a mediation, and I think it may have been Andrew Hannam or Phillip Hesketh now, it's about 3 or 4 years ago, where they came along and simply said, well, we've come to this, we've agreed with it, but we're not going to pay you anything. So you can forget it, if you see what I mean. But in both of those cases, not on those occasions, but settlement was subsequently achieved. And the other factor I think I'd make about mediation generally is it's hugely less stressful for the lawyers, because we've all been in that situation where counsel seem to be at loggerheads and have their heels dug in, and it becomes a sort of battle royale, whereas the mediators, they absorb those blows, I think, coming from the respective counsel, translate them into perhaps the better points, and then communicate them to the other side. So
yeah, I would say I'm wearing my armor plating
Yeah, well, I mean,
do vent at me. I'll pass it on in my own way.
That's the job, isn't it? So it becomes much less stressful because, and also for the claimant, I think, as well, because when, claimant's counsel come back and says, well, the defendants are saying this, this, and this, and some of the points, I remember a Court of Requiner case a couple of years ago where the defendant's counsel had taken some really unkind points, I felt, that because of her weight, she wouldn't have been able to do this job in any event. And she wasn't that big a woman. And, she cried. And I think, a mediator had interceded there and perhaps not passed that on, which I foolishly did. Then or had headed it off at the pass and said, well, I really don't think you should be saying that sort of thing because it's not going to build trust. So having that middleman in the way, so to speak, makes it a much less stressful exercise for the lawyers, and I suspect also the counsel. Just in terms of,
I was going to ask James, what about less stressful for the claimant? What's your view on that?
Yeah, I think the claimant doesn't really understand what the difference is between a JSM and a mediation, obviously, because they're not used to any of the process. But
well, aren't they in the broom cupboard usually in a JSM?
Yeah, well, I mean, I think the concept of a mediation, the word of a mediation, claimants understand that idea more. They also like the idea that they're going to be in entirely separate rooms and don't need to speak with the other side if they don't want to, which you can impress upon them in a JSM. But a mediation, you can say to them, not only in other rooms, but there's someone in the middle who's going to relay what you want to say in the way you want to say it. And I think a lot of claimants find that quite comforting. There's also quite good guidance online you can send them so they can review it in advance and so on. And my experience with both of them, JSM and mediation, is that when you have a nervous claimant who's been beaten down over the years and is quite sick of the process, I think they have a lot more faith that a mediation's gonna work.
Right.
One of the points that I do find frustrating, Paul, is we're talking about lack of consistency. I remember a few times during my practice, judges have said to me, there's no difference in practice between the courts, Mr. Valentine. But I mean, there is a difference in practice between the courts. James and I have had these 3 cases out of Bristol County Court, but I've never had the like order from most of the clinical negligence cases that I deal with are issued out of the KBD in London, and they haven't made any orders like this. We're making an application in one for a mediation, and we'll see what happens. But it's very frustrating that the practice differs so much between courts. It really should be the same, so that when you consider where you're going to issue a claim from, whether it's going to be the county court, a district registry, and the High Court, probably makes no difference in reality because it's the same judges who'll deal with it, or whether it's in the KBD in London, it shouldn't be a factor of what the court's approach to ADR is going to be. And I should just say that the Bristol County Court says that the order is made, the standard order, state immediate. The court is made without the parties' presence, obviously, and any party affected by it can make an application within 7 days to alter or vary it. And of course, it's open to the parties to say, well, actually, it's a bit too early, or actually, we'd prefer a JSM, and all the rest of it. But I think and we had this discussion, James and I, on the clinical negligence case that did go to mediation in April of this year. Whether we should say, well, should we delay it for 6 months? But we decided in the event, because the defendants have been so intransigent, because they delayed in providing us with anything or any answers to our questions, that we should just let it run. But in other cases, I can see that there could be an argument for saying, well, hang on, we love ADR, but the parties are agreed that we should do it, after another 3 months or after another 6 months. But it puts the onus on the parties then to say why you shouldn't be going for ADR at all, or at this time, rather than the sort of assumption that, get on with it, which I think is helpful. I do think it's helpful.
And what we do know from our experience at Trust Mediation is that whenever you mediate, the resolution rate in mediation, either on the day or immediately thereafter, exceeds 80%. So there's a pretty fair indication, with now a lot of cases under our belt, to practitioners in saying, look, you do consider it. It does resolve cases, and everyone wants these cases resolved. The sooner the better. Justin, when you resolve a case, we experience this as mediators where our work doesn't come to an end until we're satisfied that the parties have reduced the decision of, or the acceptance and so on, into some form of writing. Usually, if proceedings are issued, the parties tell us they're going to have a Tomlin order. Now, you have certain views about the use and abuse of Tomlin orders. I think it might be useful just to share them with our audience today.
Yes, by all means. There's a slideshow I presented. This arose out of an experience I had a few years ago now. It was an orthopedic surgeon who got dragged along the ground by a horse, and the claim was it wasn't his horse. The horse had escaped from a field. He ran after it. The people who actually owned the stables did nothing at all except tell the people who had the horses there to go and get it. So we succeeded on that at trial. It was a split trial as it happened, and then we had a JSM on quantum, and because he was an orthopedic surgeon, the value was, as you could probably imagine, quite considerable. Is a nasty shoulder injury. I don't think I'd say it's a normal that it's a Tomlin order. I'd say my own experience is probably 60% of the time. You're talking litigated cases, of course, people are content for a normal court order. And I say 40% of the time, people suddenly mention a Tomlin order. So normal court order, and after that experience where they asked for a Tomlin order, which I never particularly liked Tomlin orders, I never like things you don't, it's a bit like investing in financial instruments. You shouldn't really do it unless you fully understand it. And I don't think parties do fully understand it. Could you just go back to the first slide, actually, please? Yeah. So the normal court order after trial, if the claimant's been successful, judgment for the claimant and an order for costs, and it's just judgment for the claimant in the sum of X pounds in full and final settlement, and then the defendant to pay the claimant's costs of the action to be subject to detailed assessment. And I put 14 days there because that's what the court provides. I know defendants always ask for longer. My answer to that is, well, I can write a cheque in about a minute. Check here, nobody uses cheques these days. But anyway, I'm speaking from the claimant's perspective, and I'm bound to say that I am distancing myself from trust mediation. Any views expressed herein are not those of trust mediation. So that's the normal court order. If you can go to the next slide, please. So a Tomlin order is a form of order that avoids the entering of judgments. It's in two parts. The first part is the Tomlin order proper. It stays the proceedings on agreed terms contained in the second part, which is the schedule, and the schedule is not part of the court order. Strictly speaking, it does not have to be filed at court. The order for costs has to be in the court order proper so that the court has jurisdiction to deal with costs. The schedule, which is not part of the order, records the terms of the settlements and is a binding contract. And it cannot be directly enforced as an order of the court, but requires an application to carry the terms into effect in the case of breach. Can I have the next slide, please? So there's a standard Tomlin order. The first part is the stay. Claimant and defendant, having agreed to the terms set out in the schedule hereto, order that all further proceedings be stayed. Permission to apply. And there's the costs order, which has to be in the court order proper, so the court has jurisdiction to deal with the costs. And then the schedule, not part of the court order, says the defendant shall pay to the claimant's solicitors the sum of X pounds in full and final settlement in 14 days. The next slide, please. So the repercussions of that, interest will run on costs because the order for costs is in the order proper. So that'll be at the 8% per normal, which is obviously a good reason to make a payment on account of costs. But in the absence of a judgment, the settlement sum will not attract statutory interest, currently 8% per annum. So late payment of damages is rare, but it can happen. Probably one of my dislikes about these is many years ago, I'm talking about 10 or 15, a solicitor was not paid the damages which had been expressed to be in a Tomlin order, and he said, well, they still say they're going to pay it, they're going to pay it. It was an insurer. It was eventually paid months and months and months later. So ultimately, the only sanction is the stay would have to be lifted and the contract sued upon. Now, clearly, the defendant would pay the costs of that, but, you know, it's a very cumbersome procedure. And the rhetorical question I've put there is, why would any claimant not elect for an ordinary judgment which permits court enforcement and carries interest in favour of a mechanism which requires the lifting of a stay and then enforcement of a contract? Have the next slide, please. So why use a Tomlin order? No need to use a Tomlin order where all that is required is an order that one party shall pay money to another. And various reasons are suggested, but there's rarely any reason to use one in PI or clinical negligence litigation. So these are the reasons. If I can have the next ones. Habit. So the request for a Tomlin order may be institutionally baked in. Often, you know, defendants counsel, the solicitors say, well, that's just the way we always do it. It's just the way it's done. Well, that's not in itself a good rationale, I would suggest. The lack of a judgment, it's psychological perhaps, where the defendant is so unhappy that they're having to compromise, that the lack of judgment makes them feel better about the process. A lot of claimant solicitors that I speak to say, well, you know, that's what, you know, they want, let them have it. And of course, if you're happy to let them have that psychological, you know, making them feel better about the process after a difficult case and a difficult compromise, you know, that's fine. Avoidance of a judgment debt is mentioned with repercussions on creditworthiness. That isn't an issue for insurers or the NHSR, and in any event, a judgment is not registered for purposes of banks and loan companies if payment is made on time. And I think the last reason is perhaps one, the Tomlin order has a lawyerly aura. It feels sophisticated, especially as it's not always fully understood. And then the last reason, next one, confidentiality. The schedule to a Tomlin order is not part of the public record and so not available to third parties as of right. But is it actually confidential? If the schedule is not specifically marked confidential and there is no express or implied contractual restriction on communication of the terms, then a party could make the public the terms of the settlement. It wouldn't be appropriate for any public body, and I think Phil mentioned that the general NHSR guidance says you should not seek confidentiality of a settlement. Any agreement wished truly to become confidential should make the scope of the confidentiality crystal clear, who could be informed of what, and what the repercussions would be of breach. And as I say, it's rarely in the intention, and some vague notion of confidentiality is inadequate, especially if it is the intention that the agreement be repudiated in the event of a breach of confidentiality agreement. 20 years ago or more, I used to do employment work, as in employment tribunals, and confidentiality agreements were quite common there. And in those cases, the confidentiality agreement would be very clear. You know, you could talk to your immediate family about it, but not friends. And, you know, if there was a breach within a certain period of time, then the agreement would be repudiated and there would be a return of damages. So that's the sort of thing that you would expect for a confidentiality agreement, and generally acting for claimants in the employment tribunal, you would make them pay for it. You would make the defendant employer pay for a confidentiality agreement. So it's just as simply isn't the case that a Tomlin order per se carries any aura or sense of confidentiality. So, you know, these are the claimant's perspectives on Tomlin orders. I think they're overused. I don't think they're fully understood. And, you know, there's just simply no reason to use them. And I think that's the end of my slides on that.
Thanks. Can I just chip on the point you were referring to, Justin? The mediation agreement, the standard mediation agreement under the NHSR scheme states obviously the confidentiality, but it says that the terms of the settlement, if there's a settlement, the terms of that settlement don't need to be confidential. Of course, that can be overridden by addressing that point in the agreement itself to make it expressly confidential. That was the point to which you were referring. Yeah.
Yes, so you see I wrote an article there on it, but note it's a bit out of date.
And we as mediators are always available to mediate disputes as to the form of order. I can only recall having to do it once when the dispute over the form of order and the words of the order took longer than the actual mediation itself. But that's just my anecdote. Can I thank you, Justin, and James, Brian, and Sue for joining me on this discussion today, and I'll hand back to Phil to wind up.
Yes, I can echo those thanks as well. Thank you very much indeed for assisting today. Just a final point that we have, I think you may have seen this slide, a reference to our e-learning module and ADR Champions scheme, which you can find on their website. They're now both live, so please do take a look at that if you have the opportunity. This is our last webinar of 2025. We're back next year in at the usual time, 1 o'clock on 21st of January, 25th of February, and then the 25th of March. So we'll be sending out information regarding the content of those webinars in the usual way. Other than that, just thank you again for attending today and for all the times you've joined us throughout the year. We really do appreciate. And we do invite, we've had a very claimant-centric view today, and we would like to always balance that. So if you're on the defendant side and have points that you'd like to put and balance the views you've heard today, please do get in touch and we'll give you the forum. But thank you all very much indeed, and may I wish you, if it's not too early to do so, a very happy Christmas and Happy New Year. Thank you.